The Supreme Court will be taking up a gun rights case.
The Supreme Court today handed down a major victory for gun control advocates.
The first major federal gun safety legislation in decades is now moving forward.
21 years and older who are allowed to own a handgun will no longer need a license to carry it.
It's a law that stood for more than a century, but the court has now said that that law cannot stand.
Everybody has a right if they're a responsible adult.
The federal government just made a move that nobody saw coming, and it's about to change everything for millions of law-abiding Americans who own suppressors and short-barreled rifles. What started as a victory for gun rights has now turned into a battlefield where the most unlikely allies have joined forces against us. Here's what's happening right now. After decades of paying a $200 tax stamp for items like suppressors and short-barreled rifles under the National Firearms Act, Congress recently passed legislation that dropped that tax to $0. You heard that correctly, zero. This should have been the beginning of the end for these outdated restrictions that have burdened lawful gun owners since 1934. But something unexpected happened that's threatening to keep these regulations in place forever. The Department of Justice has taken a stance that's shocking many in the firearms community. Despite the tax being eliminated, they're arguing in federal court that all the other NFA restrictions should remain intact. The registration requirements, the lengthy approval processes, the federal database tracking, they want it all to stay, even though there's no longer any tax revenue being collected from individual purchasers. But here's where it gets even more concerning. Anti-gun cities across the nation have now jumped into this legal battle, filing official court documents supporting the DOJ's position. Cities like Baltimore, Columbus, and even parts of Texas are actively working to ensure these restrictions remain permanent, regardless of the tax elimination. Let me break down exactly what's at stake here. When Congress passed the recent legislation reducing the NFA tax from $200 to $0, several major firearms organizations immediately recognized an opportunity. Groups including prominent gun rights advocates, major suppressor manufacturers, and even 15 states banded together to file lawsuits challenging the remaining NFA restrictions. Their argument is brilliantly simple. If there's no tax being collected, then Congress no longer has the constitutional authority to regulate these items under their taxing powers. The plaintiffs in these cases are making a compelling argument. They're saying that since suppressors, short-barreled rifles, short-barreled shotguns, and other regulated items no longer generate tax revenue from individual buyers, the entire regulatory framework has lost its constitutional foundation. They've filed for summary judgment, hoping to get a quick ruling that would strike down these decades-old restrictions once and for all.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
The bill allows gun owners 21 years and older to carry a weapon without a permit.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
The Second Amendment protects the right to carry a gun in public for self-defense.
The DOJ's response reveals their strategy to keep the NFA alive despite the tax change. They're arguing that even though individual purchasers no longer pay the $200 tax, the law still imposes special occupational taxes on manufacturers, dealers, and importers. According to their brief, this remaining tax on the industry side justifies keeping all the registration and transfer requirements for individual owners. They claim these requirements form what they call a web of regulation that supports tax enforcement, even though regular citizens aren't paying anything. But they didn't stop there. The DOJ is also invoking the Commerce Clause as a backup justification. They argue that because most NFA items are manufactured and sold across state lines, Congress has the power to regulate them under interstate commerce authority. They're essentially saying that even without the tax, these items can still be regulated because they move through interstate commerce channels. The anti-gun cities that have joined this fight are making even more alarming arguments. In their court filing, they claim that removing NFA registration requirements would create a public safety crisis in urban areas. They argue that the federal registration database is crucial for law enforcement operations and that officers rely on this information to know when they might encounter these items during investigations or field operations. These cities are painting a picture of chaos if the NFA restrictions are lifted. They claim that suppressors and short-barreled rifles would flood their streets, creating unprecedented dangers for both citizens and law enforcement. They're asking the court to consider what they call the frontline impact on metropolitan areas if these items become unregulated at the federal level.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
My response to that is that's the same claptrap that they have been using for 20 years.
What's particularly frustrating about these arguments is how they ignore the reality of lawful gun ownership. Millions of Americans already own these items legally, having jumped through all the federal hoops and waited months or even years for approval. These aren't criminals. They're law-abiding citizens who simply want to protect their hearing with suppressors or own rifles configured for home defense. The city's brief also makes claims about historical tradition and legal precedent, arguing that previous court decisions support maintaining the NFA regardless of the tax situation. They're essentially asking the court to ignore the constitutional issues and focus instead on their perceived public safety concerns. This case represents a critical moment for gun rights in America. If the DOJ and these anti-gun cities succeed, it would mean that Congress could eliminate a tax but keep all the associated regulations forever. Think about the precedent that would set. Any regulatory scheme tied to taxation could become permanent even after the tax disappears. It would give the federal government a blueprint for creating unchangeable regulations under the guise of temporary taxes. The plaintiffs fighting against the NFA restrictions understand what's at stake. They're pushing back hard against both the DOJ's arguments and the city's fear-mongering. They're pointing out that criminals don't register their weapons or wait for federal approval anyway. These laws only burden those who follow the rules.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
One proposal allowing them to carry firearms without a license.
We won't see changes overnight, but it's going to be quick.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
This is a case that's been bounced around back and forth throughout the court system.
Multiple legal battles are now unfolding simultaneously across different federal courts. Each case approaches the issue from slightly different angles, but they all share the same goal, finishing what Congress started by eliminating not just the tax, but the entire outdated regulatory framework that came with it. The timing of these cases is crucial. Courts are beginning to apply more scrutiny to firearms regulations following recent Supreme Court decisions that emphasize the importance of text, history, and tradition in Second Amendment cases. The NFA, passed during the Depression era under different constitutional interpretations, may not survive this new level of judicial review. What makes the DOJ's position particularly troubling is how it aligns with the most ardent anti-gun organizations. When major gun control groups file briefs supporting your position, it might be time to reconsider whether you're on the right side of the constitutional question. Yet here we are, with the federal government and gun control advocates working hand in hand to preserve restrictions that no longer have their original justification. The suppressor issue is especially absurd when you consider the facts. These devices don't silence firearms like Hollywood portrays. They simply reduce the sound to levels that won't cause immediate permanent hearing damage. They're safety equipment required for hunters in many European countries. Yet here in America, we treat them like dangerous weapons requiring federal registration and months of waiting. Short-barreled rifles and shotguns face similar illogical treatment. The original restrictions were based on outdated concerns from the 1930s that simply don't apply to modern firearms ownership. Yet these classifications persist, trapping law-abiding citizens in a web of regulations that can turn innocent mistakes into federal felonies.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals.
Saying setting a higher threshold in an emergency could mean life or death.
When things sound really good for gun owners in court, that doesn't mean it's over.
The right to keep and bear arms shall not be infringed.
As these cases move forward, the stakes couldn't be higher. If the plaintiffs succeed, millions of Americans could finally exercise their rights without unnecessary federal interference. Suppressors could be purchased like any other firearm accessory. Short-barreled rifles could be configured without fear of federal prosecution. The artificial distinctions and arbitrary regulations that have plagued gun owners for nearly a century could finally end. But if the DOJ and anti-gun cities prevail, it would cement these restrictions potentially forever. It would establish that the federal government can maintain regulatory control even when the constitutional justification disappears. It would mean that the voices of urban politicians and gun control advocates carry more weight than the constitutional rights of law-abiding citizens. Every gun owner in America should be watching these cases closely. The outcome will determine whether the promise of the $0 tax becomes meaningful reform or just an empty gesture. It will show whether courts are willing to apply constitutional principles consistently or whether they'll bend to political pressure and unfounded public safety claims. The legal arguments will continue to develop as these cases progress through the federal court system. Summary judgment motions are pending, and judges will soon have to decide whether to end these cases quickly or allow them to proceed to full trials. Either way, appeals are almost certain, potentially taking these issues all the way to the Supreme Court. This battle over the NFA's future is really a battle over the future of gun rights in America. It's about whether we'll finally break free from Depression-era restrictions or whether those restrictions will become permanent features of federal law. It's about whether the Constitution means what it says or whether creative legal arguments can override our fundamental rights. The coming months will be crucial as these cases develop. Court decisions could come at any time, potentially reshaping the landscape of firearms law in America. The question is whether courts will have the courage to follow the Constitution or whether they'll defer to government agencies and anti-gun activists who want to maintain the status quo. That's it for today, folks. See you in the next video.